Welcome to Bond University on iTunes U.
Thanks very much, Patrick. I appreciate the introduction. It's a great pleasure, as always, to be back in Australia, and it's an honor to be able to give the Michael Jones lecture. And Ms. Lyons, it's nice to meet you. And I've known Patrick, as he said, for several years, and I think that Patrick and Ian Freckleton, Bernadette McSherry, other folks who will be participating in this or who we've worked with in the past, all very clearly exemplify the spirit of Michael Jones. So it's a great pleasure to be here. And the Baroness with her work on prison reform for years and years as well. So it's nice to be here. As Patrick said, I am always eager to come to Australia. Depending on how the election goes in a few months, I may be back here sooner than later. It is worth mentioning before I begin my talk that we do have an election coming up. Being from Florida, the state that permitted us all to Google hanging Chad in 2000 when George Bush was gifted upon the world by a narrow vote in Florida, I thought I would remind you just very briefly of how those votes got counted. Remember, the U.S. is the longest continuous democracy in the world. It has 330 million people. And this is actually a photograph of how this is an election official in Broward County, Florida, trying to sort out in 2000 which candidate, if any, the person who filled out this ballot had voted for. So in the event our election is close this time, hopefully it won't be, you'll know how we get to the final results. So, all right. Let me start by talking first about a topic that doesn't have much on its face to do with preventive detention and people with mental illness, but I think contextually is very relevant and shows kind of the drift, certainly that the United States has experienced on this issue over the last few years. On January 2nd, President Obama signed into law the National Defense Authorization Act. The act permits the indefinite confinement by the United States military of anyone who is part of or substantially supported al-Qaeda, the Taliban, or associated forces under the law of war and until the end of hostilities. This is an unprecedented piece of legislation in the United States. For the first time in United States history, the military is given jurisdiction over civilians on United States soil, and it extends the right to lock people up indefinitely on either U.S. or foreign soil for any of these reasons. And again, there's definitional issues which I think you'll see come to bear when we talk about preventive detention more generally, but also in the context of people with mental illness. It's hard really to know what it means to be part of or substantially support al-Qaeda, the Taliban, or what associated forces are. There's no definition in law. Under the law of war until the end of hostilities, and to the degree that the war on terror has been described as a war of indefinite and permanent duration, this really does extend statutory authority quite broadly in terms of the jurisdiction of the military, but also over time. Now, the president signed this into law, but then expressed serious reservations about the measure at the point at which he signed it. And after Human Rights Watch condemned the measure, and a federal district court has enjoined enforcement of the law, at least as it pertains to American citizens, the president has issued a policy that essentially turns the law on its head and says that preferentially and presumptively civilian justice system will be used in the context of confining people, at least on American soil. At the same time, the underlying statute remains on the books. And this is why, I mean, at some level, I start with the next presidential election, because it will have an enormous impact on whether this policy becomes permanent United States policy or whether it's held in abeyance, as it will be under President Obama's administration. But it's unrealistic to expect in any administration, as an election comes up, that a president will ask for the deletion of this statute. So again, it's an unprecedented statute. It turns 200 years of American history essentially on its head in constitutional and statutory law. And it shows, I think, how far, when we talk about the topic of preventive detention, and we start here, that the odds on us staying where we start are very small. And so I want to start with that to establish some context and turn to the topic of the preventive detention of people with mental illness as one example. And clearly there'll be other sort of situations over the course of this next 2 days where the issue of preventive detention will be discussed. So I want to talk about, first start with a very, very brief overview of the expanding use of preventive detention and indefinite confinement of people with mental illness in a number of countries. It's not meant to be exhaustive, simply to highlight trends that are occurring in North America, in Australasia, and in Europe. And then I want to pose 3 questions. The first is, are we doing justice in a narrow sense when we invoke these legal principles? The second is in the context of preventive detention, at least with people with mental illness. Are we safer as a result? And the third is, are there costs in social justice? Because I think one of the things that has to be considered is not only rights in a sort of a narrow sense, and certainly the erosion of procedural rights in the context of hearings on sex offenders and others is a major issue in terms with broad kind of constitutional dimension. But are there broader costs in terms of social justice? And what I'll suggest, at least in the context of the current treatment of mental illness in most countries in the world, there are enormous costs that we're paying by the invocation of these statutes. So, just very quickly, the United States has sexual violent predator statutes. One area the United States continues to lead the world is in imprisoning people. We incarcerate 765 people for every 100,000 people in the US. Australia incarcerates about 163. The Netherlands and countries in Northern Europe tend to incarcerate around 60 to 80. The biggest spike in the incarceration rates in the US was, in fact, the invocation of mandatory sentencing laws. The war on drugs followed by mandatory sentencing that causes people to have to spend longer and longer periods of time, up to 90% of your sentence is now mandated in some states. And so we've had an enormous spike to where we incarcerate people far more than any other country. On top of that, though, because of concerns over potential constitutional challenges and others, the United States has, in 20 states, created sexual violent predator statutes. And currently, and those are civil, quasi at least civil commitments of people at the end of their sentence, typically, for indefinite periods of time in what are supposed to be treatment facilities. There's currently about 4,200 people held in the United States as sexual offenders, sexual violent predators being the phrase most often used in statutes. In addition, there's 800,000 Americans registered as sex offenders. There's 3 tiers of registry mandated by federal law. In the first tier, you are registered as a sex offender for life. And so one of the things that often doesn't get discussed very much in the context of thinking about preventive detention of sex offenders is also this much broader application of sex registry laws, where people are essentially disqualified, in fact, from working in almost any context if you're registered. So this is the US situation. This is an example of the trend in one state. This is the state of Virginia. I was talking with a gentleman earlier about Minnesota, which has 600 beds and no one ever gets out. The lower line is the incarceration rate of people who fit the sex offender statute in Virginia had the legislature not broadened its application by putting more offenses into the statutory mix. The line that goes up so sharply is in fact what the practice has been. The legislature thought there were too few people being confined, amended the statute, and as a result you see this spike that has no signs of abating yet in Virginia. So instead of 130 people confined, they've got about 700, and anticipate over the next few years that figure will probably reach 900. And I'll come back to the issue of cost, at least in Virginia. Australia, you're all familiar with your laws here, obviously. Bernadette McSherry and Patrick have talked about these laws as an example of precautionary politics, which essentially means we will take a political stance that will, in this context, take away the liberty of lots of people, but because we're concerned about risk in a general sense, scientific certainty does not matter. And that's a topic that'll run through at least some of these discussions, I'm sure, over the next couple of days, this issue of how certain do we want to be and how certain can we be when we label somebody, relatively speaking, a permanent risk. So Australia certainly has joined the US in this. In the Netherlands, there's an old statute, the Tbs Statute. I spent 6 months in the Netherlands last year and came away speaking even fewer Dutch words than I did because most people in the Netherlands don't really want to spend 6 hours while you try and sort out where you go somewhere in the word. So it's the Tbs Statute. And this is a statute that's most often applied to sex offenders at the point of adjudication. People are held indefinitely. And the average inpatient stay of the cohort, as you can see on the bottom, has increased, doubled over 20 years. And so people are staying longer. In addition, there's more people going into these TBS beds. This graph ends in 2005 with 1,637 beds. The actual number now is about 2,005. So the Netherlands has continued to incarcerate more people. Germany has had a long history of preventive detention and certainly is a subject of the European court case that Chris Lebogan will talk about tomorrow. The numbers of people preventively confined there have increased, almost doubled in the last few years. In Scotland, they have orders for lifelong restriction. They've applied this to about 75 cases since 2006. And I think most interestingly, and I think to some degree most tellingly in terms of how these statutes kind of drift over broader and broader areas, there's 4 or 5 juveniles in Scotland who are under orders of lifelong restriction, which means that adolescents have been characterized as being at such risk to the public that they are under the permanent lifetime scrutiny and oversight of the state. And certainly you're familiar with England's adventures with dangerous offenders and Canada's as well. So that's a very brief and very cursory review. And I think Belgium is another country that has expanded its use, and so this goes on and on. So there's 3 issues, I think, as I said, that are worth talking about. The first is, are we doing justice? The second is, are we safer? And the third are, what are the broader implications for treatment of people with mental illness and social justice? When we think about, are we doing justice, there are certainly legal issues to be considered, but I want to talk about it in a somewhat different context. And I think 3 questions in terms of, are we doing justice to the people subject to these laws come up. The first is, are we at least committed, at least a bit, to rehabilitation and not just simply punishment? The second is, are we observing procedural norms? And the third is, are the laws being appropriately limited in their application, or do you get this kind of drift? So let me talk about each of the 3 in turn. It's interesting historically that the first wave of sex offender laws came from purely rehabilitative or therapeutic notions. The Group for Advancement of Psychiatry in 1950 published a monograph that urged states to adopt confinement of sex offenders for treatment. And it was sort of psychiatry at its height in terms of promising that if you give us virtually any group of people, we can make them better. And so this was sort of a promise that give us these folks and therapeutically we will fix them up. A quarter of a century later, in 1977, the Group for Advancement of Psychiatry came out and said, we erred. We simply made a mistake. This population is too heterogeneous. We don't have treatment modalities, and so these laws should be repealed. And when I was forensic director in Missouri, we had to say when we lived there, back in the late 70s, I got the Missouri statute repealed because I was able to persuade the legislative leadership that it was a waste of money, that you had people being held, everyone from an 80-year-old guy who exposed himself every day of the year to serial rapists up in one maximum security unit with no real treatment. There was a clinical director who wanted to keep trying drugs that the FDA hadn't approved. And there was simply no apparent benefit, and the legislature was convinced they could handle this within kind of correctional framework. And so Missouri, as a number of states did, began repealing its statutes based on the thought that the therapeutic promise had been oversold and that these statutes really didn't make much sense. When you get to this current framework, this is some of the language. This is a Kansas statute, which Kansas led the United States in this, and they characterize the folks they were after as people who do not have a mental disease that renders them appropriate for involuntary treatment under sort of existing laws. And they are predators who generally have antisocial personality features unamenable to existing mental illness treatment modalities. Now, the point I want to make with this is it's one thing to rhetorically nod in the direction of treatment, which all state legislation in the United States does because state legislatures anticipated constitutional challenges based on a premise that if these were simply punitive, then you were punishing people twice and all the arguments that you're all familiar with. But even in the context of a statute that was characterized as a civil statute, to use civil commitment, this is a very weak kind of promise of treatment, right? Because this basically says, we think these people are untreatable, and so that's kind of our stance on this. It goes to the Supreme Court, and Justice Thomas writes an opinion and says, in the bolded, we've never held the Constitution prevents the state from civilly detaining someone for whom no treatment is available, and that it'd be little value to require treatment of somebody who's dangerous when it simply doesn't exist. Now, it is clearly the case that the Supreme Court does not hold, though probably 5 justices believe, you don't have to do anything. But this is a very weak nod in the direction of treatment. And I think it's fair to characterize this commitment of at least state legislatures in the United States to treatment as rhetorical, as really, in fact, having little practical application. And so in terms of are we doing justice, are we really committed to some form of rehabilitation as opposed to just sort of nodding in the direction of it to try and anticipate legal challenges? I think at least in the United States, the answer is not very much. Australian law, as you know, I think this is an interesting kind of stance, that to argue to the United Nations, you have to permit what we do. It doesn't violate human rights because you have to be in prison to get treatment because that's where treatment is. I mean, you could also create a system where to get running water, you have to be in prison because that's where it is. But it kind of turns the notion of a commitment to therapy to some degree on its head. And the United Nations Committee was not particularly persuaded. The problem is exacerbated by what continues to be the stance, almost as a matter of dogma or theology, that people who are psychopaths are untreatable. And there's evidence that suggests that's simply not true. But this is Marnie Rice and Grant Harris, 15 years apart, 2 of the leading experts on violence and mental illness in North America, who said in 1992, treatment may make psychopaths more, not less prone to violence. That was a statement in an article that became an act of faith adopted by judges all over North America. And it's interesting if you actually look at what the treatment was upon which they made that characterization. It involved things like hot tubs, nude therapies, use of illegal drugs, and other things. It was completely bogus, to use a technical term. But that one study, such as it was, became then kind of the basis for this kind of statement of theology that you simply can't treat these folks. Marnie and Grant said the same thing in 2006. The problem, they say, are that psychopaths are fundamentally different. There's nothing wrong with them that can be fixed. Now, if you think about virtually any major mental illness over the last, take your period of time, several hundred years, virtually every category of mental illness at one point was characterized as untreatable. If you take lots of physical illnesses, they were characterized as untreatable. And so what this does, and this becomes then operationalized in terms of legal cases, is this notion that not only are psychopaths untreatable, but it's something about them, that they simply can't be treated. And so on this notion of are we doing justice, I think clearly in terms of what we think about treatment, the answer is not so much. In terms of procedural norms, which is another important part of this, not simply is process observed, but labeling these procedures as civil really obscures the point of it. These are punitive procedures characterized as civil to survive court challenges. And as Bernadette and Patrick have written, with the exception of some judges in Western Australia, courts have largely abdicated their gatekeeping role in terms of keeping out dubious testimony. This is one judge, a typical sort of thing in the US, regardless of whether or not the actual arguments are novel, the weight of the relevant community accepts them, and so this goes to the weight of the evidence and not admissibility. And courts have been, generally speaking, very uncurious, with some exceptions, in terms of exercising the gatekeeping function they can exercise as far as sorting out how expert and scientific testimony really is. So, and then the final part of doing justice is application of the law limited. The top headline is our top quote is a headline from the Washington Post a few weeks ago, in which the Justice Department, the United States Justice Department, argues that the sex predator law should be applied to nonviolent offenders as well, which would open up the application of those statutes exponentially. The second is an interesting case in which the Georgia Supreme Court, in ordering that a kid or someone who committed an offense when they were 16 could be forced to register as a sex offender, even though there was nothing sexual about the offense. It was essentially a case involving false imprisonment. There was no sexual element in anything reported, at least in the appellate opinions. And the Georgia court, in its wisdom, said you can still make the kid register as a sex offender, and having something sexual as part of the offense really was not relevant to the issue, which some might say is somewhat tautological. Would that be the word, Chris, that we were looking for? Oxymoronic. So, again, this issue of are we doing justice, I think if you look at beyond simply are we observing kind of procedural niceties in a sense, it's hard to argue that we're doing justice necessarily. Are we safer? This is an interesting question. And I'll start by saying, are we safer depends on safer than what and compared to what. So, but I think by some measures, you know, these statutes are sold on the ground that these people, that the offenders who commit sexual offenses within the codes are somehow uniquely dangerous, uniquely likely to offend over and over. As Marty Rice and Grant Harris hold, there's something about them that makes them untreatable, and therefore the only thing to do to keep us safe is to lock people up. So, 3 questions with this. Do sex offenders recidivate more than other offender classes? Does longer confinement reduce the likelihood of recidivism? And have we reduced false positives in our risk assessments to an acceptable level? The largest study done of prison recidivism was done by the US Department of Justice, in which they looked at a large cohort of people, and they found that sex offenders had a rearrest rate 25% lower than for all other criminals. Property offenders recidivated, and you can see the sort of how this lays out. Now, certainly one can argue, and if you look, as many of you have, at the records of some people committed under sex offender statutes, these are not folks any of us would want out. On the other hand, if the notion is that these are a group of people uniquely likely to recidivate more than any other category of offenders, the evidence simply isn't there. If you look at length of stay as well, does it matter? One of the other thoughts is you incapacitate somebody, the longer you keep them locked up, the safer we all become. This is from the same study, and essentially what it shows is that, looking from top to bottom, the top column is someone's incarcerated 6 months or less. 45% of those folks recidivated. But if you go down into 19 to 24 months, 31 to 36 months, 37 to 60 months, you pick up a little bit in terms of reduced recidivism, but it's not this enormous leap. And so we clearly can incapacitate, just lock everybody up till they die. But it's not clear, at least based on this study, that longer confinement by definition leads to dramatically less recidivism. If there's a paper just came out in Scotland that showed that sexual offenders are among the lowest rates of return to custody. And in England, a study looking at 2 years from release, 25% of sex offenders had been reconvicted, 47% of violent offenders had been reconvicted. So It doesn't mean we can't choose to pick any cohort of offenders and say this is a uniquely problematic offense. This does unique harm because whether it involves women, whether it involves children, whether it involves other men. So we can certainly make that case, but it's empirically not really supportable to make the case for these statutes based on the fact that these folks are uniquely, among all categories of offenders, the category of folks who offend more than anybody else. There's also the issue of risk assessment. This is an interesting statement, and it's true, by a court in Washington. Testimony regarding the future dangerousness of SBPs by its nature is prejudicial. And so the court at least was honest enough to say part of the idea you're trying to make a case. So you come in and you say this person is a significant risk based on the static 99, the PCL, what have you. And again, this notion that bring it in and we'll consider it under weight of the evidence. And the court says actuarial assessments are admissible and not profile evidence. Now, I'm not of the view that we should throw out all actuarial instruments and go back to the good old days of completely unstructured judgment, where people just came in and see, I know this guy's dangerous because I've seen 100 cases just like it. That's not really empirical opinion, empirically based opinion. On the other hand, at some level, actuarial assessments, in fact, are profile evidence, because by definition, they're saying this person fits into a broader category of people, not profile in the sense of the profiling on all the really stupid crime shows that I see Australia is emulating. I just want to say parenthetically, this is not for the record, but it is appalling if you live in the US and you have a certain point of view about Fox News, to come to Australia and every station is Fox, which I guess is because Rupert Murdoch is from here. So but it's really quite shocking to so I've tried to arrange my cable service so that no Fox station ever shows up, even if I click on it. I woke up one night trying to see if I could watch the end of the British Open, and I'm sorry what happened there. And so I'm going through Fox Sports 1, Fox Sports 2, Fox Sports 1, Australian Rules Football, Fox Sports 2, Rugby, Fox Sports 3, Darts. And the announcers are going, oh, this guy's really a superb athlete. And I'm thinking, really? He's at a bar, he's throwing darts at a board, he's like, excellent. And I thought, well, ESPN in the States broadcast poker tournaments as sports, so I guess it's all. So anyway, be that as it may. You can just blip that one right out of the... That was for Ian Freckleton, who will be here tomorrow. So, all right. So, to come back to actuarial risk assessment. Again, I'm not of the view that we should simply throw them out, because I do recall when I was a forensic director in Missouri or working with clinicians, I do recall the old days where clinicians literally would say, this person's dangerous because I've seen 100 just like him. And there's enough empirical data to show that unstructured decision-making is far worse than actuarial. On the other hand, one of the things that marked psychology and law and mental health law through the 80s, early 90s, was a very questioning attitude about basic issues. And mental health law, in part, arose out of a concern for civil liberties. And part of the questioning of whether we could predict dangerousness or assess risk was out of a concern for civil liberties. That by making it so sort of definitive in terms of testimony, but without any real evidence under it, we were violating people's rights, and that we were not doing justice. We've kind of gone all the way to the other side, and I think one of the problems with actuarial instruments that we face is that people who have developed them, and some people do take this now as a matter of almost theology and faith, that these instruments, by definition, do the job well enough that we should use them. And I would commend to you a series of, I think, some of the best papers that have come out in the last 2 years in the field of psychology and law, mental health law, whatever you want to frame it, by Dan Murray at the University of Virginia and Mark Boccaccini at Sam Houston in Texas. And what they've done is look at the use of the PCL, the psychopathy checklist, in practice. And what they found are 2 or 3 very interesting things. because the PCL, Bob Hare's instrument, is really sort of characterized as representing the gold standard in literature. It's characterized as unfailingly reliable and valid, which in field studies it seems to be. But what have Boccaccini and Murray found? They looked at 330 sex offender cases, and they looked at the PCL scores as given by the prosecution's witness and defense witness. First, they found that no score was a significant predictor of sexual violent recidivism. No score. Now, what do people do in testimony? He's got a 34, got a 36. In Belgium, it's a 2-point difference depending on whether you're on the French side or the Dutch-speaking side, how they apply the score. They make you get 2 points higher on the French side because I've been in the prisons in both, and the food in the French side is much better. And so they give you a break on your PCL scores. But if you've testified, if you've read court transcripts, people say, got a 34, off you go. Got a 26, wherever you set the cut score. What Murray and Boccaccini found first was that no score had a predictive value in practice. Now, this is not an experiment, right? This is in practice. Second thing they found, and these papers are very interesting, I think very important. They found that over time, PCL scores assigned by prosecution witnesses and defense witnesses vary dramatically. And that if you were a prosecution witness, generally, your scores over time tended to be higher. And if you were a defense witness, your scores over time, case to case, tended to be lower. And by a significant amount, not just a little bit of a difference. So again, the implication is, and they say the results suggest the stronger predictive validity values in controlled research studies may not apply to all evaluators when the PCLR is administered in the field. And so what they found is systematic bias, not deliberate, but systematic bias on the part of the witness depending on which side of the fence the witness was on over time. And that's significant because the PCL becomes the instrument in death penalty cases, in sex offender cases, with a static 99 and other things. And so if in practice the scores are that disparate compared to in experiments, that's a significant issue in terms of the credibility of the instrument. And again, I don't think you throw all these out, but clinicians aren't disciplined in how they present this stuff. Judges don't gatekeep in what they let in, and lawyers often aren't sophisticated enough to really probe at this issue. And so I would really commend these papers to anybody interested in them. All right. Social justice, implications of broader treatment of mental illness. It does cost money to lock people up. This is a shocking revelation to some people in the US. So let's talk about the cost in broader terms for the treatment of people with mental illness. And I would characterize this again as a social justice issue because it gets to do with basic distribution of scarce resources and where we put our investments. The World Health Organization has its kind of ratings of the impact of various types of disease. And they rate depression in terms of burden of disease, third worldwide and eighth in low-income countries, but first place in middle and high-income countries. And so in terms of the World Health Organization's characterization of the burden of disease, depression is one of the most significant. If you look at their rankings of the burden of disease, and they look at a variety of factors in terms of impact on ability to work, et cetera, mental status, what have you. Depression is first, schizophrenia is fifth, bipolar disorder seventh. So 3 of the top 7 illnesses in terms of the view of the World Health Organization, in terms of impact or the burden, are mental illnesses. So that's not insignificant. But then when you look at how little treatment actually occurs, these are different from different studies in different places, but in general, 2/3 to 3/4 of people in countries where this has been examined with mental illness don't get treatment for a lot of different reasons. Diabetes, it's 8%. So mental illnesses, in addition to having extraordinary impact as far as burden, as defined by the World Health Organization and others, is often untreated, which many of us know. Now, why is that relevant to what we're doing with preventive detention? There's been enormous cuts in discretionary spending on mental health across many countries. 10% of all state spending on mental health has been reduced since 2009, and there will be more cuts this year. 10% of all state funding. 17% of Dutch patients stopped treatment because they created a copay and cut 10% of the budget. Last year, the Minister of Health suggested cutting 50% of all funding for mental health. There were $580 million in cuts proposed in Australia in one category of mental health spending. And sort of the flip side of that is, as an example, in the National Health Service in England, 20% of its spending on mental health goes to secure care. 3 hospitals are relatively small and 7,000 medium to low security beds. In Florida, a third of state funding goes for 1,200 beds devoted to people found incompetent to stand trial. So we've certainly not stinted in terms of investment on the security side of things. Now, does that have any application for preventive confinement? In Virginia, which I showed you the sharp increase in the number of people confined there as one example, they spent $5.8 million on their sexual predator facility in 2005. In 2011, they've spent $25 million. They spend $91,000 per bed. 50% goes to secure staffing. 16% is medical costs, which is just sort of general, the physical illnesses people have. 10% goes for treatment. And this is a quote from a recent newspaper article in Richmond: "The detention and treatment of sex offenders represents a growing business opportunity for GeoCare," which has a big operation here in Australia, "and its competitors who hope to score lucrative contracts from state officials looking to keep predators off the streets." This is one of the biggest business opportunities in private mental health right now, running secure facilities for sex offenders and doing so for cheap, or on the cheap. It's not to say these are bad things. Sometimes these companies do far better than the state did historically. But this is, in fact, a business opportunity. Now, does this really matter to the rest of the budget in Virginia? A new national report shows Virginia's cut funding for mental health programs by 9% since 2007. They cut $40 million from programs that helped the mentally ill between fiscal year 2007 and 2011. And if you look at state after state that have sexual predator laws, if you look at countries like the Netherlands with this TBS system, more and more money is going into the preventive confinement side for a growing number of people, but still a relative handful of people, compared to or given the enormous amount of lack of treatment that most people with mental illness experience. And so if you look at the economic burden of mental illness, if you look at the personal burden of mental illness, the family burden of mental illness, and you look at where we're investing our money, we're spending more and more money on a relative few people based on assurances that we are, by definition, safer, and assurances that scientifically these people are untreatable and at great risk to the public. And it's simply based on assumptions to a large degree parading as a fact. This is a headline in the newspaper where I live. Trailer park becomes paradise for sex offenders. I have nothing against trailer parks, but it's rare that one sees the word trailer park and paradise in the same sentence. In Florida, this is what it looks like. Why? Because registration laws restrict where people can live. And the only place you can live in the county where I am are in a handful of blocks where you kind of have to cluster together, because if you don't, you violate, you're too close to the school, you're too close to a daycare center, you're too close to a church, you're too close to a hospital. This is when you cross what's called the Tuttle Causeway in Miami. This is the view. Have you been to Miami? It's pretty nice. It's not bad, right? That's not bad. So you're driving into Miami. What for 4 years did you not see? This is underneath the causeway. In Miami, the only place what eventually turned into be 90 people could live who were registered sex offenders was under the Tuttle Causeway. Probation department assigned a probation officer to the Tuttle Causeway. These guys had on their driver's license, their place of residence was the Tuttle Causeway. Because of restrictions on living, if you're registered as a sex offender, and again, there's 800,000 Americans registered as sex offenders, there's no place you can live in Miami except here. Now, this was eventually bulldozed, and it's not clear where people went. But this, I mean, again, I think just let's stipulate that a lot of these folks did things none of us would want to have happen to any of us. But this really, in terms of social justice, in terms of kind of are we doing justice, I think begs the question quite a lot. The M versus Germany case, you know, sort of are there antidotes or are there correctives to any of this? And again, I think the major issue for me is kind of the drift these laws take. From a statute designed to deal with a relatively small group of violent people to the U.S. Justice Department saying the law should apply to nonviolent offenders. From zoning restrictions that say you can't live within 2,500 feet of a school or something to zoning restrictions that say you can't live within 1,000 feet. And so we've created this large cast, basically of pariahs, labeled them untreatable by definition because of something in them, proclaim them a risk based on risk assessment tools that are fundamentally oversold in terms of their scientific merits, with a legislative commitment, essentially a sort of a nod in the direction of treatment, but not much enthusiasm for it. So, Chris, I think will talk about this case tomorrow in some detail, in contrast with the Hendricks case and maybe the Farden case you're familiar with here. But it's interesting to see what the United Nations Human Rights Committee has done, what the European Court of Human Rights has done, in terms of pushing back at this notion that government should have kind of unfettered discretion in terms of simply locking people up without any constraint. Now, I also think these are relatively conservative decisions and don't really disturb the underlying rationale for preventive detention. And I'm also of the view that we will have preventive detention of one sort or another no matter what. There's no government that will willingly give up its authority, in some cases, to preventively detain people. It just is a matter of fact. It won't happen. In the US, Justice Kennedy, who is a conservative justice who wanted to throw out the entire healthcare reform there, but also was the vote and the opinion writer saying that the death penalty could no longer apply to crimes committed by when the defendant was juvenile. Kennedy cited, briefly, some international law and was criticized endlessly by conservative pundits because he had dared to cite international law. What could that possibly have to do with the US? President Obama is criticized always for wanting to make US like Europe. My view is like, make it more like Europe? Yes, please do. That would be tremendous, because then we'd have trains and stuff that work. But these cases are important, but in terms of the US experience, at least, will have virtually no effect, I think, because there's a sort of an antipathy to international standards in law. But again, Professor Slobogan will talk about that more tomorrow. So, I'm mindful that drinks await at 6 and that that's an important stopping point, right? So in summary, I think in terms of people with mental illnesses, preventive detention is growing in a lot of different countries. It's interesting because we've kind of distributed people into two camps now. For most people with mental illness, if you're able to get treatment, it tends to be mostly for symptom relief. And so we tend not to use long-term hospitalization in a civil context anymore, for a lot of different reasons. For a small group of people, though, we give them more institutionalization than they ever could imagine asking for. And that if you look at, for the people we are confining, they're being confined for longer and longer periods of time. So in Germany, for example, the average civil commitment has increased by a couple of years. So people are being committed for longer periods of time. I showed you the statistics from the Netherlands, where the average length of stay has doubled in a number of years. In Minnesota, which created its sex offender facility in the early 1990s, one person has been released. I think because the Minnesota football team thought they could probably be of some value, so I think they recruited them for their team. Not really, that's another. So, So for a small group of people, we're spending a lot of money, increasing amounts of money, to keep people longer and longer. And whether we're getting anything in return, I think, is an open question in terms of safety. Sort of, are we doing justice? I think it's hard to argue that we are. Again, not in a narrow procedural sense, but in a broader sense. We may or may not be safer, sort of compared to what. There are enormous social justice costs, and I think in the end the question will be, will some of the principles in the various human rights conventions at least begin to influence the debate, if not to actually shape law. So with that, I will stop. I appreciate very much your attention. It's a privilege to be here, and thanks very much.
For more information, visit bond.edu.au/iTunesU.